Now I'm thrilled to continue the sixth annual review with our session 3 on labor and employment. Our presenters are Nicole Italia from to partner with Polera Mazza, where she serves as a practice group chair for its labor and employment group. Laura Mitchell is a member of Jackson Lewis's pay equity group. Susan Richards Sallin is a shareholder with Reese Broom, and Teresa Burke Wright is the principal in the Washington, D.C. region office of Jackson Lewis.
But let's get right to it. We've got a lot of time. I got a lot to cover and a little time to do it. We're going to start with COVID-19. Then we're going to move to executive orders. As you know, there's been a lot of changes just came down since we even talked and planned about this seminar. And then we're going to move to executive orders. To Fair Labor Standards Act and the National Labor Relations Board. So I'm just going to jump right into my slide, which is slide 6. And I want to talk about vaccines. The EEOC updated Section K of its what you should know about COVID-19 and ADA Rehabilitation Act and other EEO laws. I'm sure everybody has that bookmarked. And this was updated on December 16th to give guidance once a vaccine got public use, got emergency use authorization. And so the first question is, can I require my employees to take a vaccine, and how does that relate to the ADA? Well, it's pretty clear that a vaccine is not a medical examination, but when you start to ask the pre-screening questions, do you have this? Have you an allergic reaction to that? Like you do with any vaccine, it becomes a ADA inquiry that could elicit a response regarding a disability. So at that point, even because you're administering it, even if the employer contracts with Walgreens or CVS or Nova, what have you, it's your contractor, so it's your form. So if you have an employee that comes in and says, hey, I don't want to answer this, they don't get the vaccine, then you're into ADA accommodation land. If you have an employee that provides information to you, now you have disability information. So that's what happens when we offer a vaccine. The other thing is, if the employee refuses the vaccine, I don't think that for most government contractors working in an office setting that you're going to be able to meet the standard that it's a direct threat to your workforce. And therefore, I think it's unlikely that you would meet the ADA requirements to be able to say that it's an essential job function that you get this vaccine. So then you're left with, I really want people to have the vaccines. Should we go ahead and offer a telework accommodation, a leave accommodation, a flexible work accommodation? Assuming we get past all this ADA stuff and you say, okay, Susan, I'm going to go ahead and move forward with that. You still have the employee that can claim that they don't want to take this vaccine because they believe in the spaghetti god monster who prohibits them from getting vaccines. And even if you don't believe in the spaghetti god monster, your employee may have a good faith and a sincere belief in this spaghetti god monster. And then I've got to do religious accommodations for it. Now, if you don't want to do the employer mandatory vaccine program, you can say, I'm not going to do it in my office, but you have to show proof of a vaccination. That's not going to get you around the Title VII or the ADA anyway. I think most people are recommending in this scenario that we just go ahead. If you're going to have a vaccine program, great, just make it voluntary, just like you do with your flu shot. And then if your employee doesn't want to take it, you're fine. And for those employees that do, you still should have a reasonably good chance of getting your workforce vaccinated. I'm going to move on to mandatory regulations for protecting employees from COVID-19. Of course, OSHA has its regulations that they've issued, but many states have issued some pretty good mandatory regulations for this. New Jersey, Virginia, Maryland, all that listed on there, and others. And the general requirements, I'm sure you're already all observing: physical distancing, mandatory face masks that you provide, barriers if you can't maintain 6-foot distance between employees and you can't put up a barrier, sanitization materials being provided to employees so they can clean their workplace, routine screenings, establishing protocols for screening employees before they come in physically into the office and for reporting COVID-19, as well as return to work protocols, notifying others if there is COVID-19 outbreak in the workplace. Some regulations, for example, the Virginia regulation requires that you notify the Virginia Department of Health and VOSH in certain circumstances if you have 2 or more employees. You must provide training. Some regulations, again, like Virginia, require emergency plans if your office shuts down. How are you going to deliver your services? Now, I'm assuming most employers out there already have this in place if they are in Virginia or any other regulation or any other state that requires it. Just know that the Virginia Emergency Temporary Standard is no longer temporary. It's now permanent as of January 27th. So if you were just going to wait and see and let it ride out, it's too late now. And also, although it goes into a little bit onto our executive orders, but Mr. President Biden has adopted a regulation on January 21 requiring OSHA to look at whether it should have a mandatory regulation. I would expect it to be very similar to what we're seeing in the more robust states, so keep your eyes on that. If OSHA decides they need to make something mandatory, for example, face masks, that's going to come out 2 weeks of January 21. And if the temporary standards are deemed to be necessary, which I would imagine they would, those have to be issued by March 15th, 2021. So keep an eye out on that. State and local leave laws, the last part, next last part. Many states and cities and counties have adopted these emergency paid leave laws. The typical leave benefits are very similar to what you have under the FFCRA. So quarantining, public health orders, order to quarantine by a healthcare provider, if you're experiencing symptoms and waiting for a diagnosis, or if you're caring for a minor child. Some states, for example, California, has provided emergency leave by industry sector. Some states, for example, Colorado, provides that this leave can run concurrently. So you need to look at whether your state requires concurrent leave or whether it's on top of other leave. Some state laws like the FFCRA provide that benefits are not available if telework is available. So keep your eye on that as well. That can be helpful. I know I'm going fast, but I'm late. FFCRA, the Consolidated Appropriations Act of 2021. The DOL has issued guidance on the extension of the FFCRA leave. It's clear that it's no longer mandatory. The mandatory nature of the leave expired on 12/31/2020. But if you want to, and if you have employees that have not exhausted either their paid sick leave or their Emergency Family Medical Leave Act leave, you can still grant them the opportunity to use that leave if they need, and you will get the tax credit for that up until March 31st, 2021. Now, be careful. If you give your FMLA on a calendar year basis, you cannot extend that FMLA because that leave won't have accrued during the period of the original act, which was from April 1, 2020 to December 31, 2020. So I think that that covers my topics.
And Alan, in his introduction of me, mentioned that I'm part of the Jackson Lewis Pay Equity Group, and I wear that hat 100% of the time. And the other 100% of the time, I wear my affirmative action OFCCP defense hat. So today I'm going to talk to you primarily about what we are expecting from the Biden-Harris administration with respect to employment law enforcement governance by OFCCP. And it just so happens that I think the first item on that agenda is going to be pay. And really the big issue and the big tick off to that is the fact that Jenny Yang, the former EEOC chair and commissioner, has been tapped as the new OFCCP director. And as we know, Ms. Yang or Commissioner Yang, or I guess now Director Yang, we'll get her title right, was one of the leading proponents of the pay data collection tool, which we famously now and favorably call Component 2 of the EEO-1 report, which required pay data to be reported and collected by the government for all employers. In her role now as head of OFCCP, we're expecting that there's going to be a resurgence of the desire to collect pay data. The EEOC is currently undertaking review of that practice. just to see what they can do and how they can use pay data from the employer population at large. That's going to take the entirety of 2021. They just started that task force. So because of the increased importance of OFCCP, how presidents in the past have utilized that agency and government contractors as a testing ground, we expect to see pretty quick under OFCCP around pay data collection and analysis of that data. That's not to say that's the only focus of the new administration for government contractors. My colleague Teresa is going to talk about the new executive orders, the executive orders still currently in place, all of the whiplash that we've had over the past 2 weeks, and kind of, we've buckled our seatbelts and are holding on for a wild ride, I think, initially. But there's a lot of things on the agenda. And one of the topics that I wanted to talk about this morning or this afternoon was OFCCP's religious exemption. This was a rule that got finalized in December, so right at the end of the administration, but it has a pretty storied history with OFCCP over the last couple of years. And we've already seen the Biden-Harris administration in one of its very first executive orders address the issue of equality and equity for individuals on the basis of sexual orientation and gender identity. And so there's going to be, I think, a really strong interplay between religious exemptions, the laws that are on the books, some regulatory or sub-regulatory requirements that we have for government contractors, and one of the administration's key objectives to ensure that we have and are promoting equality and inclusion for all. So just a little bit of history about this executive order. So for government contractors, our kind of ground level executive orders, Executive Order 11246, and that requires that we don't have discriminatory practices on the basis of gender and race and religion. And under President Obama, the term sex was expanded to include gender identity and sexual orientation. So that's written into our executive order. We also then have a prohibition on discrimination on the basis of religion. And at times, those two constructs can conflict. And I think we really saw them pitted against each other under the previous administration. So in 2017, 2018, we saw some Supreme Court cases really come up to address the notion of religious freedom and religious exercise, as well as this issue of gender identity, sexual orientation, what rights do individuals have on those bases. In August of 2018, OFCCP issued a directive, and directives are sub-regulatory. They don't have the power of regulation. They're not published in the Federal Register, but it is something that still governs how OFCCP monitors and enforces behaviors of federal contractors. And Directive 2018 really said, we just want to make sure that everybody is aware that we've had these 3 Supreme Court cases, Hobby Lobby, Trinity Lutheran, and Masterpiece Cake Shop that have come down. And we want to remind you, including our own compliance officers, that there is a duty for government contractors to protect religious exercise and not to impede it. We also need to make sure that we are neutral in our attitudes and tolerant of religious beliefs, so that religious people and institutions can practice their faith without fear of discrimination or retaliation. On its face, those are pretty blanket, unassuming statements, but they cite, the directive cited those very specific Supreme Court decisions, cited former President Trump's Executive Order 13831, which kind of had some pretty political undertones to it. And so I think what could have been a very neutral directive really had some force and some potential conflict behind it. Following the issuance of the directive, we had a proposed rule and a finalized rule from OFCCP actually establishing in law some of these very same tenets. And that final rule is the one that went into place in December of 2020. So it was a year in the making. There was over 100,000 public comments received on this religious exemption, religious discrimination final rule because of how polarizing it was. So it took a year for the agency to take all of that into consideration. And what ultimately we have now on the books as law is a rule that says explicitly there cannot be discrimination on the basis of sexual orientation and gender identity, but you have to make sure that you are giving the opportunity for individuals of all religious beliefs to be able to administer their beliefs and have a workplace where if you're a religious organization, you can choose what individuals you want to employ in furtherance of your own religious holdings. So the directive itself in the law, the ultimate law, is very narrow in its reading, but the fear is that it can be expanded, that it's going to be expanded. So while it has been finalized and it's on the books, it has not yet been enforced because of how quickly it happened at the turn of the administration. So I think what the Biden-Harris administration and the OFCCP under Director Yang do to enforce this religious exemptions final rule is going to be really important. We also know that you can undo a law that's on the books. It just takes more time, right? It's not as swift as a pen of issuing an executive order. You actually have to work to take it to rescind that law. So there are things that the current administration are now going to have to work against and kind of undo in order, I think, to really fulfill their agenda item of equality on the basis of gender identity and sexual orientation. In addition to that, one last piece, OFCCP under former director Craig Lean started with focused reviews, meaning they took small segments of the requirements under Executive Order 11246 and started having just many audits based on those. Very successfully, Section 503 of the Rehabilitation Act had focused reviews. We are now seeing focused reviews under VEVRA, or the Vietnam Era Veterans Readjustment Assistance Act. One of the other types of focused reviews that is out there are accommodation focused reviews. And we're not just talking about disability accommodation reviews, but religious accommodation reviews, where compliance officers are supposed to examine requests for religious accommodations, potential discrimination on the basis of religious observance. And so contractors are going to be held accountable and are going to be asked questions. How do you comply with this? How do you ensure that your policies are non-discriminatory on the basis of religion? So that will be interesting to see what the new OFCCP does with those focused reviews. So really quickly, when we were putting this together, we weren't sure what was going to be the outcome of the election with respect to who was going to hold the Senate, whether there was going to be a division of power, whether President was going to have to use executive order to really get things done. And we now know the answer to that question, and we hope that there will be less gridlock as the administration kind of pushes through their agenda. But we've seen, right, that they haven't wasted any time issuing executive orders governing the behavior of federal contractors and their employees. And we can expect that to happen, I think, probably going forward for a while until we have a better understanding of really what he's going to be able to achieve through the Senate and through the legislature. So with that, I'm going to turn it over to Teresa to really talk through what is the state of the current executive orders as they impact the contractor community right now.
So thanks, Laura. We can go to slide number 8. I hope everybody can hear me okay. What we did, our panel at the end of December, right before Christmas, is we put together a list of what we thought would be the main executive orders from the past that might show up again in some form in the future. And so this was our list. And so we did this in chronological order rather than order of importance. And so now, knowing what's happened since last Wednesday, I think I would have reordered this. But we'll talk through these pretty quickly just to give you a sense of what key executive orders either are still in place and continue to impact contractors, or have been rescinded by the Trump administration, but may come back now or have come back in the Biden administration. So the first one is what we call the worker non-displacement executive order. And this is the one that basically said that contract clauses shall offer a right of first refusal to employees, non-managerial employees, on a contract when essentially the contract turns over, right? So the Acme company loses the contract to, the Beta company. And so the Beta company, if the clauses in the contract, would have to offer employment to the Acme incumbents who are non-managers. That was rescinded by President Trump in October of 2019. We expect it to come back under the Biden administration potentially. It has not yet been addressed though. And the issue there from my perspective on an ongoing basis is, how does this impact our non-compete agreements, right? Does this mean that our non-compete agreements, if we say that, if we're the Acme company and we say that our people can't go work for the Beta company, does this kind of nullify that? Does it impact the public policy factor in determining whether those non-competes are valid? And so nothing new on that front at this time. Biden may bring that back, and the issue of non-competes may arise again. The second one I'm just going to mention briefly, it's a notification of employee rights under the National Labor Relations Act. It was signed by Obama January of 2009, one of the first things he did, and it is still in place. And so nothing has changed there. Federal contractor minimum wage is an interesting issue. That's something that, again, was put in place by President Obama. That was in February of 2014. And it basically provided for a minimum wage for employees of contractors to gradually increase over time. The most recent increase issued by the Department of Labor on January 1st, 2021, is that the increase is currently $10.95 an hour. What's President Biden going to do with this? So far, no executive orders, but on Friday, the White House Press Secretary Jen Psaki announced that the president has put in place, is directing his administration to initiate a process starting on that day, on Friday, the 22nd, to allow him within 100 days to issue an executive order relating to federal contractor pay. And the issue there is, will the minimum wage rise quickly to $15 an hour? So it remains to be seen what happens with that, but it is expected to happen in the first 100 days. There also may be an increase in the emergency paid sick leave available to workers under that potential Biden executive order. So stay tuned there. Laura talked a little bit about sexual orientation and gender identity. There was an executive order put in place by President Obama that provided that government contractors are prohibited from discriminating against their employees based on sexual orientation and gender identity. This was not rescinded by President Trump, so it does remain in place. But in addition, there was a new order issued last week requiring the heads of agencies to review all existing orders, regulations, guidance, and so forth that may be inconsistent with equal treatment under the law, regardless of the gender identity or sexual orientation of individuals. It's not limited to the workplace. It's not limited to government contractors, but it's a very broad directive for agencies to consider whether some of their regulations, guidance, and so forth may be inconsistent with the idea of equal opportunity and justice based on sexual orientation and gender identity. And so again, there may be more coming down the pike in that area. The Fair Pay Safe Workplaces Executive Order 13673, this probably is like, there's probably a dusty brain cell in the back of your brain kind of waking up, because this is an issue we haven't talked about in a long time. This is something that was put in place by the Obama administration to essentially direct federal contracts to companies, to federal contractors that had an excellent record with respect to labor violations and so forth. And it required certain reporting requirements and a number of things along those lines. That was revoked by President Trump in March of 2017. But the Biden campaign has stated that not only will President Biden restore, but he will build on fair play, safe workplaces, ensuring that federal contracts only go to companies that have signed neutrality agreements with respect to labor organizing, labor campaigns, and only awarding contracts to employers who support their workers with respect to a $15 minimum wage and family sustaining benefits. Now, this was back in the late summer, early fall that the campaign was announcing this. So again, now that the president has taken office, we don't know yet how quickly this will happen, what will happen, when it will happen. But it certainly appears to indicate that President Biden is going to, breathe new life into this Fair Play, Safe Workplaces order that was signed by President Obama and revoked by President Trump. A couple of others, paid sick leave, we mentioned, that's the executive order, again, signed by Obama. It's 13706. It was not revoked by President Trump, so it is still in place. There may be additions to that because of the Psaki press briefing last week on Friday, referring to emergency leave. Finally, we mentioned the combating race and sex stereotyping executive order. That was one by President Trump that essentially significantly limited anti-harassment, racial justice, and unconscious bias training by employers. That had actually been enjoined by a court in, I think, October or November. So it was sort of limping along as it was. One of the first things that President Biden did was to formally rescind that on his first day in office last Wednesday. A few things, I guess, additional executive orders and steps that have been taken last week. There's the new executive order regarding to wearing of masks on federal property. Undoubtedly, this will impact on-site federal contractors as well. And as was mentioned previously with respect to, I think as Susan mentioned, with respect to OSHA, President Biden has issued an order calling for increased protection for workers as a result of COVID-19 and requiring OSHA to consider whether it will enact any emergency temporary standards on COVID-19 with respect to workplace protections, including but not limited to masks. Also, I think we may have seen today the restriction on transgender people serving in the military has been revoked, does not directly impact contractors, to my knowledge. And I think that's everything. I am now going to turn it over to Nicole.
All right, we can move to the next slide, slide 9. And as you can see, I think that there has been a flurry of activity. We expected there to be a flurry of activity. And there's no indication that wage and hour or actions at the NLRB are going to be any different than that. I know Laura touched a little bit on pay equity, and just to reiterate, we expect that to be at the forefront of the Biden administration and OFCCP's agenda. When we talk about NLRB and wage and hour, there are two big categories of activity right now. The first being what's happening in wage and hour at the Department of Labor. But, when you take that together with who the very possible to be Secretary of Labor is, Marty Walsh, there is a lot more overlap between the agendas than I think we have seen in quite some time. It's very clear from the Biden administration's seating of folks at the Department of Labor, even in interim positions, that the intent is to be a very labor-friendly administration. In fact, I think President Biden on the eve of his inauguration said he's going to be the most pro-union president you've ever seen. So we can expect at least a hearkening back to the level of oversight that there was in the Obama administration, and we're set to likely go beyond that. And how does this really impact government contractors? Well, in the last slide, we talked about a little bit about the blacklisting rule or fair pay safe workplaces that was around in the Obama administration. President Biden has supported the Protecting the Right to Organize Act, or the PRO Act, which was passed by the House in 2020. And although his margins in the Senate aren't significant, and perhaps in its current form will be adjusted in some significant ways, we expect the PRO Act to be on that agenda for this particular administration. And that could affect things like joint employer rules, which we expect the NLRB to take up as well. Again, the gig economy, independent contractors are likely going to be provided more ability to organize. We've seen some actions in the West Coast that indicate that the administration and states want to bring that gig economy or independent contractors into the right to organize. We expect if the PRO Act were to be passed in some current form, it would also include federal contractor debarment for labor violations, which is one of the key parts of what contractors were afraid of under the blacklisting rule or the executive order of fair pay, safe workplaces. There is a number of very pro labor friendly components of that, including making sure that state right to work laws cannot be effective anymore. That those would be gone under the current legislation, that NLRB orders would be self-executing, and that the persuader rule would come back, which basically requires those that are engaging in campaigns to disclose what they're communicating with workers. And that's just in the PRO Act. I think what we've seen right away at the NLRB is that President Biden fired general counsel because he refused to resign right away on January 20th. We expect him to, he's going to be replaced. We can also expect the board to shift to a 3-2 Democratic majority by the summer. He's already appointed the Democrat to the chair. And so we expect all of those Obama era pro-union policies to come back. For example, I mentioned earlier the joint employer rule. We expect a revision to the way that the board sees independent contractors. The joint employer rule particularly can really impact government contractors because of the way that the relationships are between subcontractors, prime contractors, mentors, proteges. So that can really impact government contractors as well as commercial businesses as well. I think what we want to touch on in the wage and hour realm is, again, we talked a little bit about the Biden administration has made it clear that they want to move to a $15 minimum wage. How that will come about, whether contractors will be affected first or not, it remains to be seen, but it's clear that that's on the agenda. It's clear that there will probably be some revisiting of the independent contractor rule. What we've seen in the Trump administration, though, is that states have taken on those initiatives to the extent that they want to take those on. And so we've seen a lot of action at the state level with respect to increasing minimum wage, which can be very challenging for government contractors that are multi-jurisdictional employers when you're trying to juggle state laws, federal contractor minimum wages, maybe prevailing wage laws. I don't think there's any danger of prevailing wage being significantly affected under the Biden administration, except to say that if a transportation bill does come to fruition, there was some concern under the Trump administration that the Davis-Bacon Act would be, there'd be a threat to it. I don't think I think we can expect that the Davis-Bacon Act would be alive and well in any type of transportation bill that comes out of this administration, given their pro-labor stance. And so I think there's going to be a flurry of movement. I don't think that is going to end anytime soon. It's kind of, in our field, it is a little bit of, hold on, get ready, set, go, I think, for at least the next year, and probably probably for the duration of this administration. One thing to note for anybody who is watching the minimum wage rule carefully, I always have to remind my clients that, under certain provisions in the FAR, if there is a change to the Fair Labor Standards Act, there are mechanisms to get price adjustments to that under 5222-43, which, so if that's a concern, if that legislation continues to pick up steam, or there's a change to the Fair Labor Standards Act itself, or to, in any executive order, we'll be watching that very carefully to the extent that price has a significant price impact, how our clients can get adjustments to those contract prices. And Laura, I don't know if you wanted to say anything else about pay equity. I know we had that kind of wrapped in here as well, and happy to let you talk a little bit more about pay equity.
No, I felt bad kind of jumping in on your topic, but I had to talk about it with Jenny Yang being named as director of OFCCP. I couldn't let that one go. So feel free if there's anything that I missed that was on your agenda.
No, absolutely. I think, it's exciting for us, maybe a little bit daunting for our clients, but from a attorney perspective, I think it's exciting to see what's happening and what's coming down the pike. But certainly it's, I think, teeing up to be a fairly daunting undertaking for our clients who are trying to just keep the reins and figuring out what they're supposed to be doing when. In fact, to the mask mandate, Teresa, I've already started getting the calls about accommodations and what if my work for the government doesn't lend itself to wearing a mask? What do we do then? And there's kind of a wait and see because agencies are supposed to be, granting the exceptions. And how are they doing this? What's the process behind it? When do you have to get the exceptions? There's so many, kind of drinking out of a fire hose issues in labor and employment right now. And I think our clients are just trying to figure out, what do I have to do today to stay above water?
Yeah, I would say that if we were thinking that there was a patchwork of laws before, I think immediately right now we are just seeing that quilt like expand exponentially with trying to figure out where you have to comply with what and what exceptions can you get for whom. And I mean, just in pay equity, I'm thinking about California has their pay data reporting. We've got the EEOC looking at it under OFCCP. Are we going to see a pay data reporting just for federal contractors? And then with the mask and COVID and paid sick leave, because there's a paid sick leave executive order. I just think that our clients are going to have a really hard time, and government contractors, you're just going to need like process flow charts all over the place to kind of figure out if yes, go here, if no, go here, to navigate and keep themselves out of trouble and in compliance over the next several months to years.
I mean, I have so many clients that have just struggled, especially nationwide clients, to deal with the patchwork, looking just, for example, at the paid sick leave laws that I've had a number of them say, at this point, I just wish the federal government would pass a federal law that applied to everybody so I'd only have one law to comply with. I think sometimes it costs more in terms of effort and resources and our time and everything for them to figure out how to comply than to simply provide the paid leave, many of which, many of our clients are already providing the right amount of leave. So it's really the cost of compliance that is just such a headache for many of them. So
right. And I think with minimum wage, right, we have in the stimulus bill the component of $15 minimum wage for everyone. If that goes through, then the government contractor minimum wage issue kind of gets erased, but that's a bigger issue for the nation as a whole. So, I think it's definitely one of those be careful what you wish for. And I really do think I hear most often is just the burden of administration with so many different variations of laws that I agree. I think a lot of organizations are hoping for some just blanket federal direction and guidance on what they're supposed to be doing in some of these areas.
I couldn't help but think last week when we saw every day, and I looked today too, there was nothing as of 1:30, there was nothing new on the White House website. But, last week I thought to myself, well, this is what happens when there are no inaugural balls, right? Like nobody's hungover on Thursday morning. Everybody's like just hitting the ground running, getting to work, right? Because there's nothing else to do.
Right.
So,
there's no hangover.
Exactly.
Yeah. And that's not even to speak of, one thing I didn't touch on since we have a minute, this idea of, we talked a little bit about non-competes, class action waivers, and arbitration agreements. And there's a sense out of the Biden administration that they want to do away with, non-competes, class action waivers, and arbitration agreements in the employment context. So, we didn't really even get much into that realm, but certainly, for clients of mine that are really getting anxious, I've been telling them it's a good time to dig out your standard form agreements that you've been using in every state that you get into and really dust them off and think about whether or not you should be using things. Using these things. Virginia now has separate penalties for having employees agree to a non-compete provision where you're not allowed to have them agree to it. So in the past, we've said, it might not be enforceable if it's stricken, you just can't use it and you may not want to do that. But I suppose if you're hell bent on using it, use it. But you can't do that in Virginia anymore, which, used to be a very employer-friendly state and is quickly not becoming as much of an employer-friendly state. So I think, contractors just always have to be on their game and looking consistently at the types of agreements they're using and what policies they're promulgating.
Well, and that was a big component of the Fair Pay and Safe Workplaces executive order, right? They dictated where you could and could not use arbitration agreements and types of claims. So I absolutely don't hesitate to think that that's going to be resurrected in the next version of that we see, that they're going to use that as an instrument to further that agenda. So that was a great point.
Let me just interject on that last point on the Fair Pay and Safe Workplaces. Because what's a little bit different, the added wrinkle here is that Congress rejected that through the Congressional Review Act. So it doesn't lend it can't by law, if anybody follows the law, can't come back in an existing form, identical form. And so we'll probably pay around the margins of what a Fair Pay and Safe Workplaces looks like. That's not the Obama Fair Pay and Safe Workplace.
Yeah, they'd have to make, and my understanding is from some folks I've talked to recently, that they are looking at how they create I think the standard is something like a substantial change in the regulatory regime, and what that might look like in order to maneuver around but not substantially change the form of, so that they could get it implemented quickly. I don't have a sense of what that is yet, but my understanding is that they're looking at that. And I think one way they're trying to get around it is through the PRO Act and implementing some penalties on government contractors for labor violations through the PRO Act.
Yeah, and that's been a goal of several members of Congress through their own standalone legislation. So we may see it come back. Questions come up from the audience about some of the minimum wage and pay adjustments. Most of the Service Contract Act that I'm familiar with, I'm less familiar with Davis-Bacon. The minimum wage there is well over $15 an hour, so probably little impact if it were to be raised to 15. Lots of clients really want federal preemption for exactly the reason you said, Teresa, to stop all the individual activities. But what's the application on these price adjustments, the fixed price contracts, fixed price federal contracts? Do the contractors get the same adjustment if the FLSA or SCA were to change? Well, let's say with FLSA.
If you're looking, the key is whether you have the correct price adjustments clause in your contract, right? So should be looking at 52222-43, which is in SCA contracts particularly. And there is a provision which allows for price adjustments on the basis of a change in the FLSA. Now, if the change doesn't raise you above what you're currently paying, that's the rule, right? It's not what the law is, but what you're currently paying employees, then, or you've otherwise escalated your contract price, then you wouldn't be able to avail yourself of that. But assuming that it does have a price impact, it's not so much whether you have a fixed price contract, but whether you have the appropriate clauses in the appropriate type of contract.
Yeah, important distinctions. And so companies ought to be on the lookout, consult with you guys early in the process with those solicitations to make sure that the appropriate clauses are in those solicitations and resulting contracts, so you don't run into those questions after the fact, because the agency's orientation is generally to not pay. Deny it.
That's true.
5 years later, we'll get it. That's going to be another panel on claims. We'll do that one. Actually, we're going to do that one later, but good conversation. One more question that's come up around the executive orders. We're still raising the questions about that, but this is a good time. Maybe I'll do this now as part of the challenge question. I'll go to that next slide, Bill, if you would, please. on the challenge question. So, as you know, been following along with us all day. I posed these challenge questions, and the panel doesn't need to answer this, but we'll offer it for others to consider. So generally, with the long list of repeals of Trump executive orders that we've seen just in the last couple of days, is it true or false? President Biden's repeal of President Trump's executive orders become operational without any further action by federal agencies. True or false? Send your answers into Craig at pubklaw.com. Put in the subject line panel 3 challenge question, and we'll get to everybody. So we'll tabulate them up, see where we go, and hopefully have lots of winners on that answer as well. I didn't have any other questions that came in from the audience at this point. So you want to continue the discussion for a minute or two before we close? We're happy to do that if there's any other points. Susan, we thank you for your effort to make it here. So anything else you'd like to add before we conclude the panel today?
I do think that people should be aware of the Virginia non-compete law. It will make any non-compete entered into after July 1 for employees that make less than $59,000 illegal and subject to fine. So it was important. It's kind of late news now, but if you could have read what was going on in January and keeping track of what was going on, the Virginia bill got your non-competes in place for those lower wage workers, that would have been okay. That was still all right. So if you have non-competes in place for a lower wage worker, be very careful about ripping those up and entering into something else, because you won't be able to get that in again. And Virginia has become a very employee-friendly law. This Virginia Family Values Act has completely changed the landscape on whether you apply for discrimination cases in federal court or in state courts. It's going to be a very interesting to watch what happens in Virginia state court cases with discrimination, because the damages are much better there now. So
Let me also add, if I might, that DC recently passed a law prohibiting non-compete agreements. It's unclear the date that law will take effect, because there are a number of things that have to happen due to DC's unique, setup with respect to congressional review and so forth. But also, if you're in DC, you may want to get those non-compete signed, because anything signed prior to the effective and applicability date of the law is okay. Anything after that will not be. I don't think it's limited to low wage workers in DC either.
It's not. It's a complete prohibition, except for physicians that make a certain amount of money and in limited context for the sale of a business. It's very restrictive, no non-compete that the mayor signed. I think even just last week, the mayor signed it.
The 11th, I think.
So all the more reason to revisit this topic, not wait a whole year. We might not even be able to wait a month before we'll have to deal with additional. I promise not to impose upon you next month, but I might be back by March or April to revisit where we stand through all of this activity. There's so much change, and this is an area where just looking at the labor agencies isn't enough. We see it out of the acquisition community. We see it in other manifestations as well. So all the more reason to stay on top of that. Ladies, thank you very much for your support today, your preparation dating back well before the flurry of activities last week. So we'll stay in touch. We'll ask you to stay in touch with us as well, and we'll look for another opportunity to have an engagement with you.